So today I'm going to talk about a federal legislative section that is about as anthropocentric as you can get. I'm going to offer a critique of this section and then talk about why I think that this very section is actually a cause for optimism. In September 2011, Congress passed what came to be known as the Leahy-Smith America Invents Act, which was the most significant patent reform legislation since 1952. The America Invents Act was the culmination of 7 years of legislative effort to reform and modernize our patent system. And while it was far from being as comprehensive as many people wanted it to be, it still was the result of a lot of thought and effort. However, on June 22, 2011, a day before the House was set to vote on the America Invents Act bill, Representative Lamar Smith from Texas entered into the bill another section which was not part of the original deliberations and careful balancing of the America Invents Act. The operative part of this section reads as follows. Notwithstanding any other provision of law, no patent may issue on a claim directed to or encompassing a human organism. On its face, this section looks pretty straightforward and quite uncontroversial, even admirable. It appears to say that we cannot patent people, which according to popular understanding is to say that we cannot turn people into someone's property. So far so good, right? Well, not exactly. Equating patent rights with property rights is a popular misperception of patents that the drafters of Section 33 apparently shared. Without going too much into patent law, which is a pain that I reserve for my students, patents are not property in the usual sense. The only right that patents give is the right to exclude others from using, making, selling, or importing the patented invention. In other words, you can own a patent, but it doesn't mean that you own the subject of that patent, only that you possess the ability to prevent others from practicing your invention. Therefore, the perception that you own a patent that covers an invention that somehow relates to a human being or organism gives you ownership of that human being or organism is wrong. I call this the ownership fallacy. As a side note, I believe that much of the public outrage about patents covering human genes was the result of the ownership fallacy and the popular misperception that patents actually give patentees property rights in people's bodies. In short, patents do not give you the positive right to sell or use the invention that they cover. And so patents directed to or encompassing a human organism do not in fact mean that the patentee owns such a human organism. But this is not even the main problem with Section 33. The main problem, as the people in this audience understand, is that we don't really have an agreed upon definition, certainly not a legal definition, of what is a human organism. Now, as Steve Wise mentioned yesterday, when lawyers and judges try to understand the meaning of a statutory term, they go to the legislative history of the specific statute to see what the legislators said about the statute prior to passing it. However, if we follow the legislative history of Section 33, we discover mostly a huge confusion by the Congress members who drafted this section as to what is and what is not a human organism, how to determine what is a human organism, and what criteria should be used in making that determination. If we read through the legislative history of Section 33, we find that the drafters use a variety of criteria, genetic, anthropological, neurologic, morphologic, to create different, often inconsistent classes of allowed patentable subject matter on the one hand, and on the other hand, to create a separate, similarly inconsistent group of non-allowed subject matter, which they pronounce human organism. For example, according to the drafters of Section 33, a human that receives genetic material from non-humans is a human organism and therefore is not patentable. Similarly, a human-animal chimera or a human-animal hybrid is to be considered a human organism. However, Non-humans that receive genetic material from humans are okay for patenting, and you can immediately see the problem here in determining at what point does a non-human become human or a human-animal chimera. Human clones are a no-no. But human stem cells and organs, including ones taken from such clones, are okay. And you can see the problem here also. Excuse me. At the same time, by focusing on human organisms, Section 33 is presumably okay with the patenting of inventions directed to or encompassing other potentially intelligent beings, such as artificial intelligence, cyborgs, de-extinct individuals from the genus Homo that are not human, imprints of human consciousness or brain in a vat type of beings, non-human, highly intelligent organisms, could be synthetic or alien, and post-humans. One thing that is clear from the legislative history of Section 33 is that the members of Congress who first came up with this section and its predecessor in 2003, which is known as the Weldon Amendment, intended to make it abundantly clear that the term human organism includes embryos and fetuses. Another problem with Section 33 is that it is drafted very broadly. If we understand this section as a normal person would, that is, not a person whose mind has been ruined by initiation into patent practice, then the prohibition on patenting anything directed to or encompassing a human organism is incredibly broad. In fact, this language seems to cover most inventions and the patents that protect them because they are all directed to humans, or ultimately are meant to be used by humans. One example that immediately comes to mind is pharmaceuticals. Pharmaceuticals are directed to humans. And yet, it's inconceivable, as Vizini said, that Section 33 is meant to prohibit patents on pharmaceuticals. Now, I can go on and on about the many other problems with Section 33, including, for example, that it reflects deep anti-science sentiments, or that it was completely unnecessary in light of existing patent laws and federal criminal laws. But this is not my main point for this forum. For those of you who are interested in why this section is a bad idea or badly executed with even worse potential results, I'd be very happy to talk to you about it later, or you can keep an eye out for my article that's going to come out in 2014. But people here are probably interested in the question of whether Section 33 and the term human organism in particular can be construed as including non-humans. The answer appears to be no. Since at least 1988, the US Patent Office has explicitly allowed the patenting of non-human organisms, including all mammals. To be fair to the Patent Office, I'll just say that it is not completely anthropocentric, and that it does recognize that members of the species Homo sapiens can be regarded as animals. So whenever mammals are claimed by a patent, the office requires that the patentee explicitly exclude human beings from what is being claimed. So Section 33 in and of itself is not such great news for this forum. Nevertheless, Section 33, despite all its deficiencies and its clear anthropocentricity, may be good news because it indicates that Congress is open to the idea and is committed to preventing slavery and involuntary servitude. The drafters of Section 33 may have been wrong in their understanding of what patents are. Their attempts to use patent laws as part of their anti-abortion legislative efforts, regardless of where one stands on the issue of abortion rights, are therefore misplaced. However, the underlying sentiments that motivated them to promote Section 33 are of the right kind, or at least that's what I would like to believe. They and everyone else who voted for this section, even if begrudgingly, were committed to preventing the kind of moral wrong that this conference is all about. As we all know, our legislators in both federal and state levels spend a lot of time on the issue of who is the subject of legal rights and who is a person for purposes of the abortion debate. I would like to propose that members of Congress put aside for just a moment, just a legislative moment, their differences on the abortion debate. Not abandon them, just set them aside, agree not to agree and ask themselves, what is it exactly that we are trying to protect? Why are we trying to protect it? And what evil were we trying to prevent by prohibiting the patenting of inventions directed to or encompassing human organisms? It may well be that trying to answer these questions, members of Congress may discover that they share a core set of values that they can agree on. For example, that what we try to prevent is the denial of freedom from those who can appreciate such freedom. Or that we are trying to avoid exploitation of one for purposes to which they would not have given their consent if given the choice. And that there may well be parameters by which we can determine who is entitled to such choice and who is able to appreciate freedom. And I believe that if we convince our members of Congress to go that way, then our federal constitution provides a perfect framework for this kind of discussion in the form of the 13th Amendment, which says in the most straightforward and explicit way that neither slavery nor involuntary servitude shall exist within the United States or any place subject to their jurisdiction. Note that the 13th Amendment does not mention the words human or person, which makes it probably one of the least, if not the least, speciesist section in the Constitution. This may arguably mean that under the Constitution, you do not have to be a person or a human to suffer from slavery or involuntary servitude and to receive the constitutional protection against them. And so, if we combine the apparent legislative will to address issues of slavery and involuntary servitude, put aside the abortion debate momentarily, and add the framework of the 13th Amendment, which gives it context, I believe that we, academics, lobbyists, policymakers, and regular citizens, can convince our legislators to turn their attention to non-humans. I think that if they do, then such an effort could bring to the recognition that at least some non-human beings ought to benefit from what we currently wrongly and wrongfully call human rights. I realize that the exclusion from slavery and involuntary servitude may not be considered as enough to many here. But as a jurist, I was taught to value pragmatism, and I believe that saving at least some non-human beings from slavery and involuntary servitude may be a good start. Thank you.